Broadcast of the special sitting of the opening of the 2020-2021 law term in the Industrial Court of Trinidad and Tobago.
Good morning and welcome to the Industrial Court special sitting for the opening of the 2020-2021 law term. I'm Paul Richards. We open with a short history of the Industrial Court and a profile of the President of the Industrial Court. In 1965, due to an antagonistic and unstable industrial relations climate, the government introduced the Industrial Stabilization Bill in the House of Representatives. The Industrial Stabilization Act was passed in Parliament on the 19th of March 1965 and was assented to by Governor General Sir Solomon Hochoy the next day. When the ISA was proclaimed, there was a dramatic change in the practice of labor relations and employment law in Trinidad and Tobago. The Act provided for compulsory arbitration among social partners, and the vehicle for this arbitration was the Industrial Court of Trinidad and Tobago. In 1967, the ISA was amended to allow for the increase in the membership of judges in the court from 5 to 7, and the amendment also enabled the court to sit in more than one division, as long as the president or vice president presided as the chairman. However, in the landmark matter of Trinidad Bakeries Limited and National Union Foods, Hotel Beverages and Allied Workers, and the Attorney General, on behalf of the people of Trinidad and Tobago, the Court of Appeal ruled that the Industrial Court had no jurisdiction to make a non-consensual order of the award for the reinstatement of dismissed workers, and that accordingly, it acted ultra vires in making such an order, end quote. In short, the Industrial Court had no power to reinstate workers. As a result, there was a second amendment to the ISA on June 14, 1967, which conferred powers to the Industrial Court to reinstate workers. The amendment also made the Industrial Court a superior court of record with all the powers inherent in such a court. The constitutionality of the Industrial Stabilization Act was challenged in the famous case of Collymore versus the Attorney General, 1967. And as a consequence of that challenge, the Act was repealed and replaced by the Industrial Relations Act 23 of 1972. The new IRA facilitated the creation of the Office of Economic and Industrial Research, the main purpose of which is to provide research to support the Industrial Court and social partners of the industry. The Registration, Recognition, and Certification Board is also a creation of the IRA. Its main function is to pursue applications which are made by trade unions for bargaining status and to issue certificates of recognition where necessary. The first amendment of the IRA was in 1978, Act 44 of 1978. This amendment provided for two divisions of the court, namely the General Services Division, GSD, and the Essential Services Division, ESD. And now for a profile of the Industrial Court President, Deborah Thomas-Felix. The President of the Industrial Court, Mrs. Deborah Thomas-Felix, is known for her wealth of experience as a judicial officer and court administrator. In 1990, Mrs. Thomas-Felix became the youngest person in Trinidad and Tobago to be elevated to the bench as magistrate after practicing as an attorney at law. Within 4 short years, she attained the position of senior magistrate. In 1995, she made a career shift to assist the government of St. Vincent and the Grenadines in the structuring and establishment of the Family Court of St. Vincent and the Grenadines, of which she became the president. The court was the first family court to be established in the Organization of Eastern Caribbean States, OECS. By the year 2000, after a period of acting chief magistrate, Mrs. Thomas-Felix attained the additional distinction of being the first woman to ever hold the position of deputy chief magistrate of Trinidad and Tobago. Mrs. Thomas-Felix was elevated to the position of member of the Industrial Court of Trinidad and Tobago in 2003 and served in that position for 6 years. In 2009, Mrs. Thomas-Felix became the first woman and third chairman to be appointed by His Excellency, the President of the Republic of Trinidad and Tobago, as chairman of the Trinidad and Tobago Securities and Exchange Commission. On December 13, 2011, after 2 years of serving as chairman of the Securities and Exchange Commission, Mrs. Thomas-Felix was appointed President of the Industrial Court. When His Excellency, the President of the Republic of Trinidad and Tobago, appointed Mrs. Thomas-Felix as President of the Industrial Court, she became the first female to be appointed to that position, and she now serves as the 6th President of the Industrial Court. In December 2014, Mrs. Thomas-Felix was appointed a judge of the United Nations Appeals Tribunal. She became the first Caribbean national to be appointed to that position. In 2015, She was elected second vice president and in June 2016 became the 8th president of the United Nations Appeals Tribunal. On November 12, 2015, she was appointed by the governing body of the International Labour Organization, ILO, as a member of the Committee of Experts on the application of conventions and recommendations, a committee composed of 20 of the world's most eminent legal luminaries who are responsible for monitoring application of international law standards. She became the first Trinidad Tobago national to be appointed a member of that committee. On March 1st, 2020, Mrs. Thomas-Felix was appointed a member of the International Monetary Fund Administrative Tribunal, an independent judicial forum for the resolution of employment disputes arising between the International Monetary Fund, the IMF, and staff members. Like the United Nations Appeal Tribunal, she became the first Caribbean national to be appointed to that position. Mrs. Thomas-Felix is the holder of a Bachelor of Laws degree from the University of West Indies, Cave Hill, Barbados, and Certificate of Legal Education, LEC, from the Sir Hugh Wooding Law School. Mrs. Thomas-Felix is also the holder of an Executive Master's in Business Administration, EMBA, with distinction from the Arthur Lord Jack Graduate School of Business and the University of the West Indies. She is certified in international arbitration in oil and gas cases. A Fulbright Scholar of the Herbert Humphrey Fellowship Program, Mrs. Thomas-Felix pursued her fellowship at American University Washington College of Law in Washington, D.C., USA. Her field of specialization for that fellowship is environmental law and health and safety. She is also the recipient of 2 other fellowships, namely the Georgetown University Leadership Fellow and the Commonwealth Judicial Education Institute Fellowship. Mrs. Thomas-Felix currently serves as a resource person for the Fulbright Herbert Humphrey Fellowship Program. She's also one of the pioneers of the Trinidad Tobago Judicial Education Committee Institute. Mrs. Thomas-Felix attained the distinguished honor of Alumna of the month of November 2014 from the University of the West Indies Alumni Association Barbados chapter for her substantial contribution to the legal fraternity locally, regionally, and internationally. In June 2017, Ms. Thomas-Felix received the Mayoral Award for National Service from the Port of Spain City Corporation of Trinidad Tobago. And in October 2018, she was among 70 of the most distinguished alumni in the region to be awarded for outstanding leadership by the University of the West Indies. She's also a published author who co-authored Judicial Training and Resource Manual entitled Domestic and Gender-Based Violence in 2003. It is my distinguished pleasure at this point to turn the microphone over to the President of the Industrial Court, Her Honor, Mrs. Deborah Thomas-Felix.
Thank you. Good morning, everyone. Thank you for sharing a moment of your time with us today at the virtual opening of the new law term of the Industrial Court for the year 2020-2021. We live in difficult times where the world is experiencing severe social, economic, and environmental challenges such as climate change, youth unemployment, and gender and economic inequality, refugee and migration issues, a decline in the demand of oil and gas, and now the COVID-19 pandemic. We know that throughout the course of history, pandemics and plagues have wreaked havoc on humanity, and sometimes they have changed the course of history. Today, humanity is being ravaged by the COVID-19 pandemic. This pandemic is causing an unprecedented scale of global disruption in the workplace. It has also created an unprecedented reduction in economic activities, productivity, and working time, with severe impact on incomes and jobs, and has resulted in a significant rise in unemployment and underemployment globally. There is continued damage to labor markets, mainly due to the imposition of lockdown measures which have been adopted to control the pandemic, including various forms of workplace closures. These workplace closures and the implementation of other containment measures, combined with the rapid deterioration of economic conditions, have caused immediate and massive losses in work hours in the first 3 quarters of 2020. According to the International Labour Organization, As at the 15th of June this year, most of a third of the world's workers, which is 32%, are living in countries which required workplace closures for all but essential workplaces. An additional 42% were living in countries which required workplace closures for some sectors or category of workers, and a further 19% lived in countries with recommended workplace closures. Taken together, the vast majority, namely 93% of the world's workers, continue to reside in countries with workplace closure measures of some kind still enforced. While the unprecedented global nature of the pandemic's impact and the collective effort to fight it has triggered comparisons to the great wars of the 20th century by various heads of state around the world, some experts, such as international economics professor Thomas-Felix, has described the impact of the COVID-19 on the global economy as the opposite of the mobilization normally seen in wartime, noting the widespread mandatory demobilization efforts undertaken to curb the spread of the disease. As Professor Vonio has stated, hibernating economies for months at a time is being in a type of terra incognita or uncharted territory for governments and businesses alike. Additionally, while we have had to demobilize business and industry to fight COVID-19, we have kept and continue to keep our eyes trained towards the future, as governments the world over have sought to create conditions conducive to preserving enterprise and jobs. In this sense, I remain convinced that globally we are all singing from the same hymn book, a hymn to preserve lives and to seek ultimately stable, sustainable development and inclusive growth for all. For we do well to remember that this too shall pass, and there is life beyond COVID-19. Thus, while the war metaphors remind us to mobilize to fight a common unseen enemy and underscore that the situation we face is urgent and critical, requiring our joint collective commitment, some countries and economies are already emerging from lockdown. Trinidad and Tobago, like many countries across the globe, has taken extraordinary and unprecedented measures to cope with the COVID pandemic. These measures include workplace closures and restrictions, bans from entering certain public places like beaches, and restrictions on the numbers of persons at public gatherings. The country has also enacted legislation to address several COVID-19 restrictions, including the wearing of masks when in public. As a consequence of the pandemic, all social partners, trade unions, employers, governments alike, now have to confront major policy challenges and changes at the workplace, which in some cases will have long-lasting implications for the world of work as we know it. We should always bear in mind that there is life after COVID-19 and consider the immense value to be gained if we adopt and adhere to international labor standards, particularly social dialogue, to assist, to promote, and to maintain a system of opportunities for all, and to obtain decent, productive work in conditions of freedom, equity, security, and dignity in the future. Social dialogue is key to the adjustment which the workplace has to make during and after this pandemic. I cannot overstate how important is a climate of robust discussion, genuine consultation and compromise built through social dialogue for the effective implementation of measures to address this pandemic and its impact on the labor market. A commitment of employers and trade unions to adjust to new and necessary workplace policy measures and to do so in a spirit of respect and compromise is important for the survival of businesses, the saving of lives, and the saving of jobs. This is a critical juncture in our history. Trade unions, employers, and workers in all sectors may want to consider the value of reviewing some of the terms of the existing collective agreements, workplace policies, and individual contracts of employment. There might be a need to re-examine and rethink some of the workplace arrangements, such as leave entitlement, health and safety rules and regulations, retrenchment, layoffs if provided for in the collective agreement, and other terms and conditions of employment. Day-to-day management issues, such as the provision of personal protection equipment for workers, arrangements for staff to work remotely, the possible rotation of staff, the re-examining of the supply chain, new customer service approaches, and new health and safety practices are now front burner issues for all enterprises to consider. In instances where there is no recognized majority union in business, it is extremely important for employers to have discussions, consultations, and meetings with workers so that the workers can have a proper understanding and appreciation of the challenges and issues at the workplace and have first-hand knowledge of any changes which are contemplated before the actual decision-making. Kindly permit me now to address some of the issues, I cannot address all of them, which have arisen in the workplace in the past few months in Trinidad and Tobago as a result of the pandemic. I have noted that several cases related to industrial relations offenses have been filed at the industrial court since the pandemic. Some of these offenses relate to business owners who have unilaterally implemented measures such as reduction in hours of work, layoffs and termination, among other things. Some of these measures are not part of the individual contracts of employment, nor are they contained in collective agreements. Yet they are implemented at the workplace without any form of discussion with the unions or with the workers. The pandemic ought not to be an excuse to flout the principles and practice of good industrial relations, to flout labor standards, and to flout the laws of this country. The jurisprudence of this court is very consistent on the issue of the unilateral imposition of new terms of employment and the unilateral variation of the existing terms of contracts of employment. It is settled law that it is unlawful for an employer to unilaterally alter the existing terms and conditions of employment of workers. Employers are reminded that they must respect and adhere to the rule of law when making these tough decisions, which affect the livelihood of workers and the survival of their businesses. In times like these, employers should not consider a unilateral approach to the resolution of issues in the workplace. This is a time to have discussions and to get buy-in from everyone, especially the workers, and to encourage peaceful resolution of these unexpected problems which have arisen as a result of the pandemic. I urge employers in all sectors to appreciate the need for workers to be kept informed, consulted, and to be made aware beforehand of decisions to introduce new policies and changes to the workers' terms and conditions of employment. Additionally, workers should be informed on what steps they can take for their own protection, the protection of their colleagues, and at the same time contribute to the containment of this pandemic. The second issue which I would like to discuss relates to COVID-19 restrictions and union activities. A few months ago, there were protests and gatherings by some unions which was said to be related to the breakdown of negotiations and collective bargaining. These protests and gatherings took place during the period of the restriction of movement of citizens. Trinidad and Tobago has ratified the Freedom of Association Convention, which is one of the fundamental conventions of the ILO, and it is considered to be one of the ILO's primary safeguards for peace and social justice. This convention gives trade unions, among other things, the right to collective bargaining. As we know, during collective bargaining, if there's a breakdown of negotiations, trade unions may protest, march, and essentially exercise the right of freedom of association. Freedom of opinion and expressions, in particular the right of trade unions not to be penalized for raising their voices through public protests, are essential corollaries of freedom of association. However, freedom of association may be subject to restrictions and suspension. I will repeat that. Freedom of association and the related fundamental rights are not unfettered and may be subject to restrictions and suspension during certain periods of crisis. I think we can all agree that the restrictions of those fundamental rights ought to be done only in circumstances of certain gravity and in conditions that any measures affecting the application of those rights are limited in scope and duration to what is strictly necessary to deal with the situation in question. As noted before, there have been lockdown measures and restrictions on the movement of the public imposed by the government to combat the pandemic in Trinidad and Tobago. As a result, the number of persons who can participate in large public gatherings have been restricted. These restrictions should be seen in the context of the gravity of the COVID-19 pandemic and justifies, in my view, the reason to restrict the crowd gatherings to a minimal number. Although these restrictions will affect large gatherings by unions, it is my respectful view that they do not amount to an abuse by the state, but rather a decision by the state to protect citizens. I urge trade unions to remember this, to bear this in mind when there is collective bargaining or breakdown in negotiations, and I respectfully suggest that they create new ways for their voices to be heard and to voice their protests during the pandemic. I will now address the issue of job losses in a general sense because the industrial court adjudicates upon individual cases related to job losses. Globally, there is what can only be described as chaos in the world of work. A number of people have been losing their jobs, some job functions have been suspended, some people have reduced work weeks, some people's jobs have been retrenched, some jobs have become redundant, and some workers have been terminated. Generally speaking, workers whose employment is terminated due to the economic impact of COVID-19 or for health and safety reasons should be entitled, if they qualify, to severance benefit or some type of separation benefit. On the other hand, some small businesses have not survived the effect of the pandemic and may not have the resources to pay workers who qualify for severance and ex gratia payments. These are the issues which require discussions so that workers can get an understanding of the true picture of what is happening in the business, and this is why social dialogue is so important. As a basic principle, the employment of a worker should not be terminated in the absence of a valid reason for such termination connected with the capacity or the conduct of the worker or based on the operational requirement of the undertaking. The temporary absence from work due to illness such as COVID-19 or family responsibility during the pandemic does not constitute a valid reason for termination. It is important for employers to understand that termination is different from retrenchment. The latter occurs mainly due to economic reasons, and the law provides a structure and a process when it is contemplated. The provisions in the Retrenchment and Severance Benefit Act may be useful to those employers who are contemplating retrenchment as a solution to the economic crisis. I pause to add that the government, which is the largest employer of workers, has taken the progressive step and put in place leave arrangements within the public service for workers who are absent from duty from March 16th to June 21st as a consequence of circumstances associated with the COVID pandemic. The effect of COVID-19, particularly the layoff and retrenchment of workers and the reduction of work hours of some, have widened the economic inequality gap globally, and some families are struggling to cope financially during this pandemic. There is no social protection or benefits for workers who are victims of COVID-19 or any crises in Trinidad and Tobago. The National Insurance Scheme provides protection and benefits for illness, for sickness, maternity, injury, retirement, invalidity, employment, injury, death, survivors, and funeral grant. However, the National Insurance Scheme does not provide benefits and protection to workers who have lost their jobs due to no fault of their own, and in this case, workers who have lost their jobs due to the pandemic. In March this year, the government introduced a temporary unemployment relief grant for persons during the breakdown who have lost their jobs due to the pandemic. A related issue, and one which is of concern to several employers and workers, is the bureaucracy involved in the payment of severance benefits. Several persons have been retrenched recently due to the impact of COVID-19 on businesses, and some of them have not received their severance packages. This is so not because the employers have not processed and computed the severance payment, but due to the fact that the documents have not been processed speedily at the Board of Inland Revenue. Workers cannot receive their benefits unless that process is completed. Several employers have expressed grave concern about the legal obligation to make severance payments within the statutory period and at the slow pace of processing these applications at the Board of Inland Revenue. While I'm not defending the Board of Inland Revenue, these are not normal times. The reality, as I see it, is that there is an ongoing rotation of public servants, including the staff at the Board of Inland Revenue, due to the COVID-19 pandemic. I dare say that this, together with the increased volume of severance applications which have been submitted by employers at this time, can cause delay. However, I know that employers and workers are anxious to have this issue resolved, and resolved urgently. On a lighter note, there is a paradigm shift in the workplace. More and more people across the globe are embracing new working methods, and employers are implementing new training and reskilling policies. One such method is remote work. Trinidad and Tobago, since the pandemic, there have been meetings of unions and employers to discuss the myriad issues which have arisen in the workplace. As a consequence, several employers have embraced remote work, and they have allowed their employees to work outside the traditional office environment. It is my hope that social partners will pool their collective wisdom to identify the modalities of remote work in Trinidad and Tobago in order to have a smooth transition to this new working method. For example, they may need to examine issues which may appear to be simple, but which in fact can prove to be problematic. Issues such as who absorbs the cost of electricity, internet charges, workstations, among other things, and what measures are in place to address the general security and integrity of the job, such as cybersecurity. The main takeaway from this crisis is that the workplace and the world of work as we know it has changed forever, and the employers and unions play a key role in assisting workers to navigate these uncharted territories and in assisting to stabilize the labor market. Social dialogue at the tripartite level, where government is involved, is critical and allows for policy engagement and policy making through the National Tripartite Advisory Board. I will now turn to the work of the court. The Industrial Court, like many other businesses in Trinidad and Tobago, closed its offices to the public in March this year and reopened on the 8th of June due to the COVID pandemic. Since that time, we have instituted a rigorous sanitizing regime for the court's buildings. My sincerest thanks to the MTS crew who have given us their much needed support. And I must make special mention and say thank you to Mr. Anthony Roberts, Chairman of the Sawo Regional Corporation, and the workers of the corporation for making arrangements to have the Port of Spain building sanitized in the months of May and again in the month of August this year. There are new practice directions and protocols with respect to the entry and use of the court's buildings, like in most other places since COVID-19. This year, the court on the 29th of June embarked on a pilot project for the remote hearing of case management conference cases and mention and report. To date, we have adjudicated upon 503 case management cases remotely. We've also been conducting an online survey with you, the stakeholders, to determine whether this is the best approach for the future and to address any concerns which you may have. The feedback we have received so far is very encouraging, with 23.4% of the users rating their experience as excellent, 54.7% rating the experience as very good, 20.3% as good, and 1.6% thought the experience was fair. There have been concerns expressed about the waiting rooms by some persons, and we are actively addressing these concerns. Currently, we have been making use of the Zoom platform. We do intend to begin using Microsoft Teams as well in about 2 weeks' time. There have been several requests by legal practitioners for open court hearings and conciliations to be conducted remotely. However, the Industrial Court currently does not have the resources and the equipment to provide these services. I wish to thank you, the stakeholders, for your support in this pilot project and the feedback you have provided to us about your experience so far. The library. The library's digitization project, which began in 2012, continues, and to date, out of a collection of 4,603 judgments, which spanned from the year 1965 to present, 2,921, which is 63% of the court's judgment collection, have been digitized. Additionally, in spite of the interruption of the library's work calendar due to the COVID-19 pandemic, there has been an increased demand for online access to the library this year, and the court received subscription payments of $203,500 to date. The sum collected last year was a bit less, which was $199,004. These subscription payments are deposited into the consolidated fund. There has been a marked decrease in new cases filed at the Industrial Court in the year in review, which is September 15, 2019 to September 14, 2000. This is mainly due to the fact that the court and the Ministry of Labor closed their offices to the public for approximately 3 months as a result of the pandemic. A total of 905 new cases were filed, with 500, which is 505 cases less than the same period last year. The court disposed of 707 cases this year, and the disposal rate this year is 78.1%, which is 17 percentage points higher than the period 2018-2019, when the disposal rate was 60.9%. 240 judgments were delivered this year, 94 of which were delivered when the court reopened its doors in the month of June to August. I want to congratulate and thank the judges and the staff of the court, particularly the court reporting section, for utilizing the period when the court was closed in March to May to prepare the notes and deliver the judgments. As I reported last year, the court continues to face challenges for space, human resource, and financial resources to manage its operations. These challenges continue to hinder the court's ability to provide the best quality service to the public. I will not repeat what I said last year. As I close, it will be remiss of me not to mention that health experts, both locally and internationally, have provided guidelines and protocols to help to fight this silent, unseen killer called COVID-19. The main guidelines and protocols deal with personal hygiene, the wearing of masks, and social distancing of 6 feet or more from persons. I urge stakeholders and the public in general to follow these guidelines, because by following the guidelines, we protect ourselves, we protect our families, we protect our friends and our loved ones, and we can save lives. As we look to the future, the reality is, for us to survive the gathering storms on the economic and health front, stakeholders at all levels and in all sectors need to engage in a sustained collective effort to stabilize the labor market and to strive to maintain our current economic and social gains as a nation. This engagement will be testimony to genuine social dialogue and attest to the strength of our social partnerships. This is a time to rise to the occasion, as we have done it in past crises, and we no doubt will continue to do so, as we draw inspiration from our national watchwords: discipline, production, and tolerance. I thank you for listening. Do have a good day.
You have been viewing and listening to an address by Her Honor Mrs. Deborah Thomas-Felix, President of the Industrial Court of Trinidad and Tobago, at this special sitting of the Industrial Court for the 2020-2021 law term opening. Her Honor focused on several issues in her address, including giving a global overview, which included identifying the International Labour Organization at the 15th of June this year, which stated most of a third of the world's workers, which is 32%, were living in countries which required workplace closures and all essential workplaces. And she identified an additional 42% were living in countries which required workplace closures for some sectors or categories of workers, and a further 19% lived in countries which recommended workplace closures. Taken together, the vast majority, nearly 93% of the world's workers, continue to reside in countries with workplace closure measures being enforced due to the COVID-19 pandemic. Her Honor also identified Trinidad and Tobago, like many countries across the globe, which had taken extraordinary and unprecedented measures to cope with COVID-19, including restrictions, including workplace closures, restrictions, and bans from entering certain public places, beaches, and restrictions to the number of persons in public gatherings. She identified that we should always bear in mind there's life after COVID-19, and social dialogue was the key to the adjustment in the workplace, which we had to make due to COVID-19 and the pandemic. She also identified that in this critical juncture, trade unions, employers and workers in all sectors may want to consider the value of reviewing some terms of the existing collective agreements, workplace policies, and individual contracts for employment. They may also need to re-examine and rethink workplace arrangements and remote working opportunities included in these revised contracts. The second issue Her Honor dealt with was the issue related to the impact on union activities. And also, Her Honor touched on the issue of job losses and the responses and responsibility of employers, including workers whose employment were terminated due to the economic impact of COVID-19 for health and safety reasons, should be entitled, if they qualify, to severance benefits of some type of separation. She took some time to identify a basic principle of the employment of a worker should not be terminated in the absence of a valid reason for such termination in connection to the capacity or conduct of a worker based on operational requirements undertaken, and the temporary absence of work due to illness such as COVID-19 or family responsibilities during the pandemic. Her Honor also focused on the Retrenchment and Severance Benefit Act, which she pointed as being useful to employers contemplating retrenchment as a solution in some cases to the economic crisis. It was not all bad news. Her Honor also focused on the paradigm shift in the workplace and new opportunities, and the fact that some workplaces are embracing new working methods, employers implementing new training and reskilling policies, and remote working opportunities. She also focused on the impact of the court itself and its operations. She identified 905 cases and a reduction in the number of cases because the court itself was impacted by closures in the early stages of the pandemic restrictions, and the fact that the disposal rate was in the vicinity of 78.1%. And of course, the court embarking on a pilot project for remote case management conferencing, and the reviews where that was concerned in terms of the feedback received, 23.4% rating the experience as excellent, 54.7% rated the experience as very good, 20.3% rating as fair, and as good, and 1.6% rating as also fair. Her Honor also focused on the progress made by the court in the library digitization project, which began in 2012, and which is 63.5% of the court's judgment now being digitized. So that kind of brings an end to the broadcast of the ceremonial opening of the Industrial Court for the 2020-2021 law term, and of course the opening address by Her Honor, Mrs. Deborah Thomas-Felix. On behalf of the entire team, we thank you for viewing and listening, and we take you back to Master Control.
That was the live broadcast of the special sitting for the opening of the 2020-2021 law term of the Industrial Court of Trinidad and Tobago.